Hi, welcome to the news.And for November 2nd, 2020. It's Plan Your Epitaph Day. Mine is Get Off My Dick. It's also Practice Being Psychic Day. A lot of people are participating, especially considering it's also Election Day Eve here in the United States. Now, you're going to get a lot of news about the election and a lot of jokes about the election from a variety of people, some of which are actually joking. But what I'm going to do instead is talk about something else, something completely different. Well, not really different, but a little bit different. And just the one thing. That's right, today is a special report. And today's topic is constitutional originalism. I realize that sounds drier than a California forest just before a gender reveal party, but stick with me. I assure you there will be something good at the end, or not. I'm not psychic, nor am I practicing. It's more of like a cultural psychic. Due to the recent confirmation of Justice Amy Coney Barrett, no relation to the hot dog, originalism has been in the news. Barrett's presence on the Supreme Court was sold with the promise of an originalist justice, a theory that her mentor, Justice Scalia, popularized. With the help of the folks at the Federalist Society, she was confirmed because we live in a society. Just so you know, originalism isn't the only game in town. Originalism stands in contrast with the living constitutionalism and similar sentences previously espoused by judges, lawyers, justices, and others. I do want to say here a few things. I am not a lawyer. I am most certainly not your lawyer. And there are several types of originalism. I'm only going to be discussing one of the originalism types here because the others are even more stupid. And trust me, this one is pretty stupid too. If you're going to go on with me about not being a lawyer, I'm pretty sure you are not a lawyer. And even if you are, you're sure as shit not my lawyer. And you're sure as shit not my constitutional lawyer. Got it? The primary school of originalism is original meaning. Meaning that it looks at the meaning and the circumstances of the law when it was written. In the Constitution, this is from 1787, and from 12 years ago, this was Obamacare. You get the idea. This seems sensible. How else would you define things? After all, other than the words that are on the page. But we'll get there. We'll get there. Let's start with your problem of words on the page, as originalists claim, and forget the linguistic postmodernism for a tick. If one were to use the words on the page, that would have a huge effect on how we govern and how the laws are applied, primarily because we already do not use the words on the page. Why? Well, for example, the U.S. Constitution clauses 11 through 14 provide Congress with the power to provide and maintain an army and the Navy. There's no such provision for a Space Force, or even an Air Force for that matter. Are these entities unconstitutional? An originalist, if they were principled, would be forced to say yes. I mean, they're not principled, but if they were. But then I can hear you say, planes and spacecraft didn't exist in 1787, and that's very true. But that's not what the text says. It doesn't matter if things progress. That's what the text says, and that's what originalists mean. Really? Seriously? They could have chosen a broader term, the founders, like armed forces. Though, again, I suppose a soldier of any stripe would probably have arms, or else how else could they do all those push-ups they show in basic training movies? That's just one example. I got more. An originalist would be forced to make women ineligible for the rank of representative, senator, or president. Jen, we know he used to be a gender-neutral term. But do we? It's certainly not what they meant, because there was no push to involve women. Indeed, even their voting rights were resisted at first, and that was only resolved via this 19th Amendment. And further, that's not what the text says. The text says he. It doesn't end there. If we look at the war powers, technically we have not been at war since 1945. So none of those veterans whose service people think all the time really went to war. Of course they did. We know they did. But again, that's not what the text says. The text says no war without congressional approval. My grandpa loved this fact because he really didn't want Vietnam and Korean vets in the damn VFW because he fought a world war and they didn't. The effects of this are pretty startling because if there was no war, there are no veterans. When the last World War II veteran dies, do you expect the Department of Veteran Affairs to just close up? All right, we're done. What about my Agent Orange symptoms? Sorry, Congress didn't declare war, so your injuries are your problem. You can see where this goes, don't you? I mean, if you're an originalist, that's what it says, right? That's it. It means what it says, and that's it. Sometimes the words aren't even on the page, and the meaning of the original words is lost, which is plainly visible in the Second Amendment, where our militia is referenced, and I can promise you that the militias are not regulated wellly. But it also can be turned on its head. The Fourth Amendment, what's an unreasonable search? In 1787, it probably had nothing to do with my smartphone, a breathalyzer test, or certainly the contents of my bladder. So, pretty cool. But that's not how originalists define the term reasonable. They have something else. It's not just the Constitution. We don't know for sure, and it's a guess when we think you do. A fucking guess. As Neil Gorsuch, another textualist, has explained succinctly in the recent Bostock versus Clayton County case. He said that we do not know what people think when they pass laws, even when they have what appears to be clear language. There was no way to know what was intended. That Bostock decision affirmed that LGBTQ people are covered under federal discrimination laws. He brought that up. He brought that up that it was involved with sex. It's possible that legislators may have intended to include LGBTQ inclusion. It's not like that nobody knew about us. LGBTQ people have existed for as long as people. There were protests for queer folks in 1964, that same year the law in question was enacted. And not long afterwards, some people were putting up gay and trans lawsuits pointing to the law. As Gorsuch said in closing his decision, quote unquote, judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations. Unquote. All's fair, right? Obviously not, because that made a bunch of conservatives very angry. You win some, I lose some, I guess. So let's take a quick rundown of things that you may or may not have the right to do, depending how close you read one chunk of the First Amendment that contains the right to free speech and the freedom of the press. Fair? Post on a blog? Sorry, writing is not speech. Do you own a blog? Well, you don't own an actual printing press. Do you own your own server and host? Again, you don't own an actual printing press. It may seem like one, but it's not. If you want to write on paper, that press thing, you should really pick one of those up on Amazon. Oh, so you can operate a press and own one. And a press only. And you could talk. Cool. But it's not the framers' fault. They left it out. But again, fucking originalists ignore it. It's called the Ninth Amendment. The Ninth Amendment is basically an etc. of rights. The Ninth Amendment states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Others retained by the people. Is healthcare right? I'd say yes. You could even use this for an argument for universal healthcare. If healthcare is a right, somebody must provide it, so the government should provide it. Some claim people have no right to an abortion, but that's not what the Ninth Amendment says. Clearly. Is it a right to masturbate with a vibrator? The answer to that last question is no, if you're Ted Cruz. That seems like a joke, but it's not. Senator Ted Cruz said the ability to stimulate one's own genitals with a device is not a right. Yeah. He spent time with that argument, and then faved a porn tweet. I mean, is your freedom to post stupid words on Twitter a right? I'd say no, because Twitter is a private company and can do as it wishes with the platform. Does the platform have an obligation to do business with you? I don't know. Do they have rights? More on that later. We'll get there, I assure you. We could see from this that the idea of originalism is firmly rubbish. It's a lie conservatives made to offload their bigotry on history and to hand-wave some interpretation of some judicial or legislative decisions that claim that it's not their job to legislate from the bench. Indeed, and if you are calling a law constitutional or not, you indeed are. But they can't even do that right. Remember when I brought up postmodernism? I gave away my copy of Infinite Jest, so you just have to trust me that I've read it. Our laws can be read however you would like, and that's a problem. For starters, it means that corporations are people. It also means free speech rights are the equivalent to money, per Buckley versus Vallejo. It also means if you're rich enough, you can have more speech, as we've learned in Citizen United versus the FEC. It means that companies have religious rights, per Burwell versus Hobby Lobby, and the dozens of lawsuits of bigots hiding behind their religion to seek. If companies were really able to make those arguments, we could see a knock-on effect of disastrously ludicrous proportions. Like, for example, I know you disassembled the U.S. Post Office, but the DeJoy Delivery Service has a clear opinion on the place of women, and they should not be able to vote. So, we can't handle her ballot. Sorry, it's our religion. Rest assured, it goes one way, because you know when the Supreme Court hears a Satanist claim she has a religious right to an abortion, it's going to be interesting. They'll throw it away, but it'll be interesting. I digress. Back onto my wheelhouse. Postmodernism. Because originalists are not really originalists. They mix everything up. We have given rights to corporations like this with free speech, and then we smash it into what a postmodern vision of a person is, a corporation. Per the original text, corporations are not people. Can you imagine verbiage like this in a Supreme Court decision? At issue in this case is regulations promulgated by the Federal Exchange Commission that restrain the ability of non-corporeal entities from voting. Companies do not have biological eyes or other sensory organs, and therefore are not able to be literate, and such requirements may be considered in violations of the rights of persons regardless of their corporeal state. Under the Americans with Disabilities Act, this is unconstitutional. And yeah, it's been a few moments since I made a joke, but I made this is super honestly scary stuff. Not as scary as imagining Trump naked, but probably pretty close. But the groundwork, as opposed to Rudy Giuliani, is already laid. And with such originalists like Coney Barrett, modern corporation-friendly super precedents are going to mix with these supposedly plain text interpretations of long-dead slave owners that wrote and signed it in 1887. But all hope is not lost. Things like Board versus the Brown of Education and Loving versus Virginia are what Barrett called super precedents, which means they're settled law. Theoretically. Until we decide what settled means something different. So progress can be made, but that's not the goal of Barrett. Conservatives do not look for progress. Conservatives stand to thwart history and yell, stop. Those other things are history. Loving versus Virginia, Brown versus Board of Education, even if those things are in living memory of some of my friends. Nor did she include Roe versus Wade, or even the most recent Obergefell versus Hodges in these super precedents. God help me, but let me quote Thomas fucking Jefferson here. Laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truth is disclosed, and the new manners and opinions change with the change of circumstances, institutions must advance also and keep pace with the times. We might as well require a man to wear the coat which fitted him when he was a boy, as civilized society to remain ever under the regimen of their barbarous ancestors. Laws and institutions. Not laws only, not institutions, but both. Because he was smart enough to know that sometimes shit doesn't happen as quick as we need, and we need to go faster than now as we grow together as a worldwide culture. Again, originalism is a lie. Originalism is a lie conservatives made up to give way to their bigotry. It's the legal equivalent of loving the Donna Reed show and thinking the 1950s were great. It doesn't make sense. Yes, the United States is a nation of laws, and laws are words, but those words serve as only pointers to ideas. And we never have had the same idea. The idea of yellow in your head is different than mine, and that's a color that I can point to. Your idea of something abstract, like rights, is not mine, and that's okay, usually, unless they intersect with mine. We must acknowledge first that these men lived when bloodletting was state of the art. They say the past is a foreign country, and that would be a whole other world completely. Then we must realize no matter how clever they may have been, our future should not be held back by those who could not imagine modern life. And those same men dared not even imagine a world where every person in their country was truly free.